Hi friends, today I'm going to discuss with you another significant topic of law called LIS pendens. This is pertaining to the civil cases, and the provision of LIS pendens is given under section 52 of the Transfer of Property Act. When the matter is pending in the court of law, when the proceeding in respect of immovable property is pending in the competent court, that is called lis pendens. The word lis pendens is the Latin word. The meaning of the same is pending litigation. When any suit or proceeding is pending in respect of a immovable property before the competent court, then it is called lis pendens. The law related thereto is explained or given in section 52 of the Transfer of Property Act. Certain conditions need to be fulfilled. Certain essential ingredient has to be there so as to attract the section 52 of the Transfer of Property Act. What are those? Which we are going to discuss in detail, and we will also be giving examples related thereto, how this law is applicable, etc. What are the exceptions to this, etc. First of all, we should know the essential ingredients which are applicable to the doctrine of lease pendants. To attract the provision of lease pendants, certain ingredients are there. Number one, that suit or proceeding must be pending in the competent court, and that should be related with immovable property, and right in respect of that immovable property must be in a question directly, should be in a directly and specifically in question. In such a cases, number three, the parties to the litigation, that is defendant or any other persons, are not allowed to sell or alienate the property. They cannot sell or alienate the property or cannot create any sort of right like third party right in respect of that property during the pendency of the case. And fourth ingredient, and the alienation of the property or transfer of property is done by the person, is done by the parties, then and then only section 52 of the Transfer of Property Act is applicable. Because third ingredient says that the party cannot sell or cannot create or cannot alienate the property because the suit or proceeding is pending in the court. So as long as the matter is pending in the court, the party are not allowed to sell. However, the party sells out or creates third party right or alienate the property during the pendency of the court, that is in contravention of the law and without the permission of the court, then section 52 of the Transfer of Property Act is applicable. And the effect of this section is that the person buyer who purchases the property from the defendant, because defendant will definitely sell the property, then this section will be applicable. Then the buyer who purchases the immovable property from the defendant is not party to the suit. In that case, it may happen that the buyer may sell the property to third one, third person may sell the property to fourth one may sell to fifth one, etc. Number of transaction may take place during the pendency of the litigation because there are chances. Therefore, it is highly difficult for the plaintiff to make all the person as a party, because in his suit, in a plaint, he will pray in the prayer that no third party right shall be created by the defendant or by his agent, etc. However, if the B, C, D, E, F, those the prospective buyers are not party to the suit, then in such a cases it is highly difficult for the plaintiff to make the all them party to the proceedings. Therefore, even if the persons who are not party to the suit, who purchases the property from the defendant, are also bound by the judgment of the court. It means the effect of section 52 of the Transfer of Property Act is that the buyer who is not party to the suit is also bound by the judgment, that is decree or order of the court. that order or judgment outcome of the litigation will also be binding upon him. Tomorrow, that buyer cannot say that, no, no, I was not party to the litigation, therefore I cannot be bound by this order. No, the law is that the buyer, prospective buyer who was not party to the litigation, is also bound by the outcome of litigation, that is judgment or decree of the suit. This is law. So these are the essential ingredient of section 52 of the Transfer of Property Act. However, there is exception to this when the matter is pending in the court of law, that is competent court, and the defendant or any of the party who is interested obtains the permission of the court by making appropriate application before the court, and during the pendency of such a litigation, as interim relief, the court allows the party to purchase the property. In such a cases, the principle of this lease pendants will not be applicable, because that person has obtained the permission of the court. When the sale or alienation of the property in question took place with the prior permission or leave of the court, then the section 52 of the Transfer of Property Act is not applicable at all. Now, another question arises whether this law of lease pendants is also applicable to the arbitration proceeding, because in most of the cases we see that there are agreement between the parties, like a person takes the loan, there is always a clause or specific agreement is there that in case of any dispute or differences between the party, the matter should be referred or shall be referred to arbitrator instead of filing litigation. In that case, section 89 of the CPC says that there is a bar to file a civil suit in the court when there is a clause of arbitration. In such a cases, the arbitration proceeding has to be filed. If such an arbitrator decides the case like a suit or dispute in respect of the property, then question arises whether the principle or law of section 52 of the Transfer of Property Act, whether it is applicable or not applicable, because the arbitrator is not the actually, in fact, is court. The answer to this question is given by the Honorable Apex Court in a judgment called Mohan Singh, one of the judgment called Mohan Lal Majors versus Tara Singh, which I would like to put in the comment. It says that yes, obviously, even if the arbitrator has conducted the proceeding, section principle of section 52 would be applicable to the arbitration proceeding also. Now, what happens generally? A person who is interested in the property will file litigation in the court, and he will seek interim relief as no third party right shall be created by the defendant or his agent, that is stay in respect of the property, and he may claim ownership in respect of the property or any specific direction from the court directing the defendant to execute the sale deed in his favor. Meanwhile, what happens generally, to defeat the purpose of this proceeding or suit, the defendant with his mischievous mind may transfer or alienate the property during the litigation to defeat the purpose of these litigations. So it should not happen, because plaintiff has made the defendant only party and not the prospective buyers. So even if the prospective buyers are not party to the litigations, the judgment or outcome of the litigation, that is decree or judgment of the court, will also be binding on the buyer who was not party to the proceeding. It is like right in rem. Those prospective buyer may be A, B, C, D, whatever, because during the pendency of the litigation there may be a number of buyers. So it is highly difficult for the plaintiff to make all the buyers as a defendant or parties to the suit and to claim the relief against them. Therefore, the principle says that it is binding upon the buyer whether he was party to the suit or not. During the litigation, when it is pending, the plaintiff can do one thing. When the matter is pending in the competent court in respect of immovable property, he can register the notice of lease pendants with the registrar of assurances. Likewise, where the documents are registered in respect of the property, in respect of like sale, mortgage, etc. With that office, he can register notice of lease pendants. However, registration of notice of lease pendants with a register of sub-assurance is not mandatory in nature, it is only optional. If the plaintiff goes for registration of the same, he will get certain benefits out of that. Anyone who wants or wish to purchase the said property, while purchasing the same, he will make a search in the sub register of assurance offices, and in case if he finds that there is already notice of the lease pendants is registered, then he will not buy, and he will come to know that there is a litigation pending in the court of law in respect of that. Therefore, he will not buy that, because the buyer, they do not know whether any litigation is pending in respect of the property in which they are interested or which they are going to buy. It is difficult to check whether litigation is pending or not. In case if the notice of lease pendants is not registered with register of assurances, if the notice is registered, that will protect the plaintiff and his right, because the purpose behind section 52 of the Trans Property Act is to protect the right of the plaintiff and buyer of the property. Buyer of the property would be bound by the judgment of the court, that is decree of the court. Even in case suppose the order comes in favor of the plaintiff, then he will a suit will be decreed. In case if the order of the court goes in favor of the defendant, and defendant has already transferred the property to some other person who was not party to the suit, then such a person will be bound by the order or decree or judgment of the court. Hope that I have covered the essential ingredients of the lease pendants, when it is applicable, and what are the exception to that, that is when the permission of the court is obtained, in that case the rule is not applicable. Similarly, I remember one thing, that when the court conducts auction in respect of the property to meet out the revenue, that is taxes of the government in respect of that property, in that case the transfer or alienation of the property is not voluntarily, it is involuntarily, because it is done by the court. In that case also, court said that there is a judgment which says that the provision of section 52 of the Transfer of Property Act is applicable. And these two judgments I would like to give in the comment box also. Those who are interested, they can also refer the same. Thanks for hearing to me. Hope that you like my lectures. Hope that I'm adding your knowledge. Hope that I'm expressing well, and hope you like my videos in future too. Thanks.